question that the Supreme Court still has on the table is a very simple, seemingly simple question: are human genes patentable? So this is the result of a lawsuit that's been going on since May of 2009, and it involves several patents, 7 patents that have been taken out on 2 genes that are associated with risk of breast and ovarian cancer. And as the case has progressed through the court system, there are 2 kinds of claims in these patents. One set of claims were about the way of detecting differences in these genes, that is, mutations that are associated with risk. Those method claims have all been handled by the lower courts. 5 of those claims were thrown out and 1 of them was preserved, but that's no longer under dispute at the Supreme Court. The one remaining question is patents on the DNA molecules themselves from these 2 genes, and whether those molecules, those DNA molecules and mutations in those molecules can be patented. To scientists, a discovery is something that you find in nature. And an invention is intuitively something that you think of and didn't exist before, and it involved human intervention. And those feel like they're 2 totally different things. But in fact, if you think about how we do research and development, and for example, just take this example of the genes for breast and ovarian cancer. These are genes that exist in everybody's body in normal form. And what we've noticed is that when there are specific mutations in those genes, then you have higher risk of cancer. These genes were found by identifying families that had lots of cases of breast cancer initially, and then it turned out that those families also had ovarian cancer in them. So it's breast and ovarian cancer. And the crucial scientific breakthrough was in 1990 when Mary Claire King discovered that a little piece of chromosome 17 was associated with the people who got cancer in these families. So that was a very strong signal that, hey, you know what, there's a gene there to be found. So what's the scientific process? Well, the scientific process is to look for the mutations in a gene that you know must be there, because you look at the inheritance pattern and you know that there's a gene to be found. So is that a discovery or an invention? Well, to most scientists that feels like a discovery. You knew it was there. Everybody was racing for it. There were teams all over the world trying to find these genes. Mary Claire King was one of those teams. She led one of those teams. She was then at Berkeley. She's now at the University of Washington. There was the team at Myriad. And then there were teams in Europe, Mike Stratton's team and Marie Stopa-Lionnet in France. So there were lots of teams all over the world that knew that there was this gene to be found. And we would call that discovery in science. From Myriad's perspective, however, they did something really clever. It clearly involved the hand of man. It wasn't obvious to do, or somebody else would have found it before then. It was new. Otherwise, they wouldn't have gotten, such a prominent publication in Science magazine. Is it useful? For sure. So they met the patent criteria, and from their perspective, well, of course, then it's an invention. We aren't patenting the DNA in your cells or my cells. We're patenting the DNA that you would create in a test tube as you're doing this test. So from their perspective, they have met the criteria for an invention. From the perspective of a scientist, the intuitive response is no. They discovered a gene that we knew was there to be found, and they took approaches that were relatively well known, and if you did them for long enough, you would find these mutations. So that's where we are. There will be a fair amount of discussion about this word isolated. And I gotta tell you, patent lawyers have very different opinions about what that word is doing. There was an Australian court, for example, that had a trial over the BRCA1 gene. This went to trial in February last year, and the decision came down just last month. And the court basically said that What isolated meant is you've created an artificial environment, you've done something artificial, and therefore you can get a patent. The arguments that the American Civil Liberties Union and Public Patent Foundation are making in the Myriad case are basically, no, isolated basically is being used as a magical word to allow Myriad to claim in patents any way of basically finding mutations in these genes, and therefore they are covering something that would be found in nature. So those arguments are what's going to be presented to the Supreme Court, and to tell you the truth, there's nobody on the planet right now who can tell you what that word isolated means, because what really matters is what does it mean in court, and only the court systems can answer that question for us. And now it's gone all the way up to the highest court in the land, and by June 30th we will have some inkling, maybe, of what this word isolated is doing in those patent claims. A couple things to say about the effect of the patent system on research and discovery. First, we did a whole bunch of studies of 10 clinical conditions and what was the role of patents or lack of patents in those. And I think we can reach two pretty strong conclusions. One is that in most of the cases it didn't matter too much whether there were patents or not. That is, the same discoveries would have happened without the patent incentive. So the folks who claim that these discoveries never would have happened but for the patent incentive are surely wrong. So that's, you can throw out the strongest, oh, it only happens if you have strong patent protection, that set of arguments. On the other hand, for people who are saying patents have no incentives at all, they're wrong. Because in two of our case studies, genes that were associated with diseases were actually discovered by companies. Those companies were doing that R&D precisely because they thought they could get patents and they might be able to make money if they did so. And therefore, it's fairly clear that what the patents have done in this little part of the world, that is genetic diagnostics, is it has induced some private research and development capital that wouldn't have existed without the patent incentive. So I think we can throw out the both extreme arguments that patents make no difference. Well, yeah, sometimes they do. And the argument that the only way we're ever going to discover anything is to have patents, no, not true. There's a lot of NIH funding, a lot of the same things would be discovered, it would just take longer, and it wouldn't be done with nearly as much private capital. So that's kind of where we are. I actually think there are really, really good arguments on both sides. That's why this is such an interesting case. Every judge that has seen this case has written many, many, many pages on this. Judge Sweet, Robert Sweet, in the district court in New York was the first judge to see this. His opinion was 158 pages long. What's that tell you? It tells you the arguments are really intricate and that there are good arguments on both sides. So this is what's going up to the Supreme Court, and we'll see what they do with it.